Good afternoon, friends. Let us dive into writ petition civil of 1099 of the year 2019, which was decided on 11th December 2023. Friends, this is relating to Article 370 of the Constitution, which has been newly added in our syllabus. So, friends, the bench which listened the writ petition was of 5 judges bench, Dr. D.Y. Chandrachud, CJI, Honorable Justice Sanjay Kishan Kaul, Honorable Justice Sanjeev Khanna, Honorable Justice B.R. Gwai, and Honorable Justice Surya Khan were members of the bench. Friends, the issues for consideration were Article 370 of the Constitution of India incorporated special arrangements for the governance of the state of Jammu and Kashmir. The President issued Constitutional Order 272 and 273 during the subsistence of proclamation under Article 356, subclause 1B, which orders had the effect of applying the entire Constitution of India to the state of Jammu and Kashmir and abrogating Article 370. Contemporaneously, the Parliament enacted the Jammu and Kashmir Reorganization Act 2019, which bifurcated the state into two union territories, namely the Union of Jammu and Kashmir and Union Territory of Ladakh. The petitioner challenged the constitutionality of these actions. CO 272 was issued under Article 370, subclause 1D, and sought to amend clause 3 of the Article 370. The petitioner challenged CO 272 as being ultra-vires Article 371D on the grounds that it modified Article 370, which could only be done on exercise of powers under Article 370, subclause 3. And only the state government may accord concurrence to the President under the second proviso to Article 370, subclause 1D. Further, the exercise of power under Article 370, subclause 3 in issuing CO 273 was challenged. The questions for determination were whether the provision of the Article 370 of the Constitution were temporary in nature or whether they acquired the status of permanence in the Constitution. Second was whether the amendment to Article 367 of the Constitution in exercise of power under Article 370, subclause 1D, so as to substitute the reference to the Constitutional Assembly of the state referred to in clause 3 of Article 370 by word Legislative Assembly of the state was constitutionally valid. So this was the issue, whether Constituent Assembly, the wording can be changed to Legislative Assembly of the state. And third was whether the entire Constitution of India could have been applied to the state of Jammu and Kashmir in exercise of the power under Article 370, subclause 1D. Whether the abrogation of Article 370 by the President in exercise of power under Article 370, subclause C3 was constitutionally invalid in the absence of recommendation of the Constitution Assembly of the State of Jammu and Kashmir as mandated by the proviso to clause 3. Whether the proclamation of governor dated 20th June 2018, an exercise of power confirmed by Section 92 of the Constitution of Jammu and Kashmir and subsequent exercise of power on 21st November 2018 under Section 53, subclause 2 of the Constitution of Jammu and Kashmir to dissolve Legislative Assembly were constitutionally valid. Whether the proclamation which was issued by the President under Article 356 of the Constitution on 19 December 2018 and subsequent extensions were constitutionally valid. Whether the Jammu and Kashmir Reorganization Act 2019, by which the state of Jammu and Kashmir was bifurcated into two union territories, Union Territory of Jammu and Kashmir and Union Territory of Ladakh, were constitutionally valid, bearing in mind the first proviso to Article 3, which requires that a bill affecting the area, boundaries, or name of the state had to be referred to the legislature of the state for its views, and second proviso to Article 3, which requires the consent of the state legislature in increasing or diminishing the area of state of Jammu and Kashmir or altering the name of the boundaries of state before the introduction of bill in parliament. Whether during the tenure of proclamation under Article 356 and when the Legislative Assembly of the state is either dissolved or is in suspended animation, the status of the state of Jammu and Kashmir as a state under Article 1 subclause 3A of the Constitution and its conversion into a union territory under Article 1 subclause 3B constitute a valid exercise of power. So friends, these were the issues. It was held as per Dr. D.Y. Chandrachud, CGI, for himself, B.R. Gawai, and Suryakant, JJ. The state of Jammu and Kashmir does not retain any element of sovereignty. After the execution of the Instrument of Accession, IOA, and the issuance of proclamation dated 25th November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. This was stated at para 514 of the judgment. As per Honorable Justice Sanjay Kishal Kaul, in light of Supreme Court prior finding in Prem Nath Kaul case, the state of Jammu and Kashmir retained an element of internal sovereignty, despite Maharaja Hari Singh signing the IOA with the Dominion. Article 370 of the Constitution recognized this internal sovereignty by recognizing the Constituent Assembly of the state. This is at para 112. As per Honorable Justice Sanjay Khanna, the abrogation of Article 370 does not negate the federal structure, as the citizens living in Jammu and Kashmir do and will enjoy same status and rights as given to the citizen residing in other part of the country. This is stated in para 2. Constitution of India, if we go by Article 356, Constitution of Jammu and Kashmir, Section 92, proclamation issued under Article 356 of the Constitution of India and Section 92 of the Constitution of Jammu and Kashmir, constitutional validity of. This is the question as per Dr. D.Y. Chandrachud and B.R. Gawai and Honorable Surya Kant, Justice. The petitioner did not challenge the issuance of proclamation under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamation does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. This is stated at para 514. Now, as per Dr. D.Y. Chandrachud, Dr. B.R. Gawai, Justice B.R. Gawai and Justice Surya Kant, the exercise of power by the President after the proclamation under Section Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of proclamation. The person challenging the exercise of power must prima facie establish that it was a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shift to the union to justify the exercise of such power. The power of Parliament under Article 356, subclause 1V, to exercise the powers of the legislature of the state cannot be restricted to law-making power, thereby excluding non-law-making power of the legislator of the state. Such an interpretation would amount to reading in a limitation into the provisional contrary to the text of the article. This is stated at para 514. As per Honorable Justice Sanjay Kishal Kaul, who was concurring with Dr. D.Y. Chandrachud, CJI, President's rule can be imposed after the dissolution of State Assembly since the presidential emergency was predicated on the failure of constitutional machinery which took place prior to the governor's rule and dissolution of the assembly by the governor of Jammu and Kashmir was only a subsequent consequence. Once the presidential proclamation has been approved by both houses of parliament so as to reflect the will of the people, the president has the power under Article 356 to make irreversible changes, including the dissolution of the state assembly. The imposition of an emergency highlights an extraordinary situation, and in the absence of state government and state legislature, the power of these elected organs must lie with any other competent authority. Article 357 does not bar the president from exercising the non-legislative powers of the state legislature, and Article 356 subclause 1B allows the Union Parliament to exercise all powers of the state legislature without distinguishing between legislative and non-legislative powers of the state legislature. Therefore, President is permitted to exercise both legislative and non-legislative function of the state legislature. However, a proclamation of emergency is bound by judicial and constitutional scrutiny to ensure the exercise of emergency powers is not unfettered and absolute. This is as per reference to para 112. Now, friends, as per Dr. D.Y. Chandrachud, Honorable CGI, Justice B.R. Gawai, and Justice Surya Kant, it can be garnered from the historical context for the inclusion of Article 370 and placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. This is at para 514 of the judgment. Now, as per Honorable Justice Sanjay Kishan Kaul, concurring with Dr. D.Y. Chandrachud, a combination of factors such as Article 370's historical context, its text, and its subsequent practice indicate that Article 370 was intended to be a temporary provision. This is at para 112. Now, as per Honorable Justice Sanjay Khanna, concurring with both Dr. D.Y. Chandrachud and Justice Sanjay Kishan Kaul, Article 370 was enacted as a transitional provision and did not have permanent character. This is in para 2 of the judgment. As per Dr. D.Y. Chandrachud, Dr. B.R. Gawai, and Dr. Surya Kant, and Justice Surya Kant, the power under Article 370, subclause 3, did not cease to exist upon the dissolution of the Constitutional Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transition power recognized in the proviso to Article 373, which empowered the Constitutional Assembly to make its recommendation, ceased to exist. It did not affect the power held by the President under Article 370, subclause 3. This is stated at para 514. Now, as per Justice Sanjay Kishan Kaul, who was concurring with Dr. D.Y. Chandrachud, Article 370, subclause 3 contained the mechanism to bring the temporary arrangements to an end and in turn to de-recognize the internal sovereignty of the state and apply the Constitution of India in toto. Since Article 370 is meant to be temporary arrangement, it cannot be said that mechanism under Article 370 subclause 3 came to end after the state constituent assembly was dissolved. The power of the president under Article 370 subclause 3 was unaffected by the dissolution of the Constitutional Assembly of the Jammu and Kashmir. The president could exercise their power anytime after the dissolution of the Constituent Assembly of the Jammu and Kashmir in line with the aim of full integration of the state. Friends, this is stated at para 112. Now, friends, moving further, as per Dr. D.Y. Chandrachud, D.R. Gawai, and Surya Khan, Article 370 cannot be amended by exercise of power under Article 370, subclause 1D. Recourse must have been taken to the procedure contemplated by Article 370, subclause 3. If Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir, paragraph 2 of the CO 272, by which Article 370 was amended through Article 367, is ultra-vires. Article 371D, because it modified Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. However, the exercise of power by the President under Article 370, subclause 1D to issue CO 272 is not nullified. The President in exercise power under Article 370, subclause 3 can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the government of the state or union government acting on behalf of the state government under the second proviso to Article 370, subclause 1D, while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Article 370, subclause 3, for which the concurrence or collaboration with the state government was not required. Paragraph 2 of CO 272 issued by the President in exercise of power under Article 370, subclause 1D, applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not nullified merely because all the provisions were applied together without following a piecemeal approach. The President had the power to issue a notification declaring that Article 370, subclause 3, ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370, subclause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370, subclause 3, is culmination of the process of integration and as such is a valid exercise of power. Thus, CO 273 is valid. The Constitution of India is a complete code for constitutional governance. Following the application of Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273, the Constitution of State of Jammu and Kashmir is inoperative and is declared to have become redundant. This is stated at para 514. The power of the President under Article 370, subclause 3 was unaffected by the dissolution of the Constitutional Assembly of Jammu and Kashmir. The President could exercise their power anytime after the dissolution of Constitutional Assembly of Jammu and Kashmir, in line with the aim of full integration of state. Hence, CO 273, which declares that Article 370 shall cease to operate except as provided and was issued under Article 373, is valid. The power to issue CO 272 without the concurrence of the government of the state is valid, as the power of president is not limited by the concurrence of the government of state in this case. The power under Article 370, subclause 1D, read with Article 370, 367, cannot be used to do indirectly what cannot be done directly. The power to make modification under Article 370, subclause 1D cannot be used to amend Article 370 and Article 367, which is an interpretation clause, cannot be used to alter the character of provision. Therefore, paragraph 2 of CO 272, which amends Article 367, subclause 4 is ultra via Article 370. However, the President has the power to apply all provisions of the Constitution of India to Jammu and Kashmir under Article 370, subclause 1D, which is similar to the power under Article 370, subclause 3. Therefore, remainder of the paragraph 2 of the CO 272 is valid. So, friends, these were the rulings of the findings of the Honorable Justices. The Justice Dr. D.Y. Chandrachud CJ, B.R. Gawai, and Honorable Justice Surya Kant J. held that the views of the legislature of the state under the first provision to Article 3 are recommendatory. Parliament's exercise of power under the first provision to Article 3 under the proclamation was valid and not nullified. The Solicitor General stated that the statehood of Jammu and Kashmir will be restored. In view of this statement, it is not necessary to determine whether the reorganization of state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, the validity of the decision to carve out the union territory of Ladakh is upheld in view of Article 3, subclause A, read with explanation 1, which permits forming a union territory by separation of territory from any state. Steps to be taken by the Election Commission of India to conduct elections were to the Legislative Assembly of Jammu and Kashmir constituted under Section 14 of the Reorganization Act of September 2024. Restoration of statehood shall take place at the earliest and as soon as permissible. So, friends, as per respected Honorable Justice Sanjay Kishan Kaul, concurring with Dr. D.Y. Chandrachud, the challenge to Section 4 of the Jammu and Kashmir Reorganization Act on the touchstone of Article 3 is not required to be debated on account of assurance on behalf of the Government of India that the statehood of Jammu and Kashmir would be restored on elections being held. It is imperative to ascertain the views of the state legislature under the first provision to Article 3 if the proposed will affect the area, boundaries, and name of the state. However, in the instant case, since the state of Jammu and Kashmir was under previous rule and state legislature was already dissolved, the functions of the state legislature were performed by the Union Parliament. Hence, it was not possible to ascertain the views of the state legislature. It follows that Section 3 of the Reorganization Act is also valid. So, friend, this is all about what I want to say in this video. See you again in another video. Thank you for watching. God bless you all.